All rise. Court of Appeals is again in session. Please be seated.
Good morning. Welcome to the Utah Court of Appeals in special session in Cedar City on the lovely campus of Southern Utah University. This session is held in conjunction with the university's A.P.E.X event series, which basically means we will have, once I've offered a few preliminary remarks, a very normal session of court with arguments from both sides. And then court will be in recess. We will take off our robes to emphasize that court is over. We will take some seats at the front of this podium and do a question and answer session. Thank you. It'll be a Q&A, as they say. Typically, the past few years, that Q&A has been moderated by University President Scott Wyatt. He is out of town on other university business and will not be able to do that today. But we have Stuart Jones, who is part of the university administration, and like President Wyatt, is a lawyer by training. He will help us with the Q&A. I might mention that this is the 10th time that the Court of Appeals has had a session in Cedar City. 6 of those 10 have been on the university campus, and the last 5 of those have been in conjunction with either the colloquium or the A.P.E.X event series during President Wyatt's tenure as president. I want to thank our clerk of court, Lisa Collins, and Lynn Vartan in the A.P.E.X events department and her fine staff, along with Jennifer Oberhelman in President Wyatt's office. All of them work very hard to pull this event together. We have the easy part of it. We read briefs, we hear arguments, we decide cases, but obviously for this to happen, it requires the work of all of them. I'd also like to thank Trooper Brian Barrett with the Utah Highway Patrol and the Southern Utah University Police who handle our security. We understand that many of you have classes that you will need to go to, the students who are in attendance. There's also a bit of a line to clear security, so people will come in. People who need to leave for their classes will feel free to do that. It won't offend us. We understand that you may have other things you need to do. All we ask is that you leave as quietly as possible. And in that regard, I would ask everyone to make sure that their cell phones are silenced. When we're in our regular courthouse in Salt Lake City, it's a $100 fine if your phone goes off. You're looking at the person who holds the record for the most fines. I've fined myself $300 plus $50 when my text thing went off. That wasn't quite as disruptive. Lawyers have been fined a total of $200 for their phones going off. Quite honestly, you won't be fined if your phone goes off today. But we would surely appreciate being spared that distraction. And so just as a matter of courtesy, please make sure that your phone is in the silent mode. With those preliminaries then out of the way, other than for me to point out what a delight it is for us to be once again on the campus of Southern Utah University, let me tend to the more traditional court business. We allow 15 minutes per side for oral argument. Appellant can save some of that time for rebuttal. And if you let me know at the outset how much time you want to save, I'll help you keep track of it. But ultimately, it's your responsibility. You've got a digital clock there on the podium. When it's showing all zeros, it's time to sit down unless you're in the middle of answering one of our questions. We live stream the proceedings. When we're in our regular courthouse, we do the same here, and we make a record of the proceedings. So it's very important that counsel don't stray too far from the microphone or we won't have the benefit of your remarks on the record or the live streaming. It's important to stay near the mic. Similarly, each time counsel comes to the podium, if they would be so kind as to state their appearance for the record so that if we're later listening to the arguments, we can be reminded of who is saying what when. With those instructions out of the way then, unless I've forgotten anything, or unless counsel have any questions, we'll call the case of Rojas versus Montoya.
Good morning, Your Honors. Jacob Stone here for the appellants, and I am reserving 3 minutes for rebuttal. May it please the court, we're here because the district court's decision to deny relief on the basis of Rule 60B1 was an abuse of discretion.
You're going to have to pull the mic up. Or lean over, I guess.
And the court's decision to deny relief on 60B4 was incorrect. On 60B1, in terms of mistake, mistake is its own distinct source of relief under Rule 60B1. And it envisions the kind of mistakes of a clerical nature, an oversight, something simple like that. It doesn't go to a mistake in the court's application of the law. It doesn't go to a mistake in legal strategy. It's purely a simple clerical mistake that unfortunately has significance.
Can I ask you a threshold question?
Yes.
I understand that the trial court made a reference to the defendants somewhat tag teaming in defending this case, not an uncommon occurrence. But when it comes to a motion to set aside a default judgment, and specifically the facts of this appeal, don't we have to treat Mr. Montoya and Ms. Swanson individually and look at the merits? I can ask a follow-up question which will show why it's important, but don't you have to look at them individually and not collectively?
Yes, Your Honor, I would agree with that. They are individual defendants, and especially in this case where their joint counsel had withdrawn, they were on their own.
Okay, and so the follow-up question is, one of the issues here is there's a claim that whether it was a mistake or excusable neglect, it flows from the fact that they claim not to have gotten notice of whether it's withdrawal of counsel or the pretrial conference or whatever. And so it appears to me that as it pertains to Ms. Swanson, it's acknowledged that the withdrawal of counsel was received, I believe, but the timing was off because she was out on vacation. Do I have that right?
Yes, Your Honor. She went on a months-long vacation out of the country, and it coincided right around the time when the notice of withdrawal was sent, and so she did not receive it until several weeks later.
And that's fundamentally different than what we have for Mr. Montoya, right?
Yes.
Okay. And what should we do with that?
Well, Your Honor, I would say that first, in terms of mistake, I think mistake, if we are looking at them separately, mistake very much applies to Mr. Montoya's situation. His withdrawing counsel put a bad address down, and because of that bad address, it just kind of metastasized, and it grew to a point where he got no notice of this pretrial conference and didn't show up. In terms of Ms. Swanson, considering her separately, I would say excusable neglect specifically applies to her. The lower court faulted her for not making arrangements with somebody to keep apprised of the case while she was on her vacation. But she did make those arrangements. She made them with Mr. Montoya, and I can't think of a better person for her to have made those arrangements with. He was acting as the lead defendant. Her brother, was very involved, so I don't know who else she would have made arrangements with.
When the mistake is, because obviously the attorney generally acts as on behalf of the party, when the mistake in the case is that of the defendant's attorney, is that mistake under the rule, or does that simply give rise to potentially a claim of the client against the original attorney for making the mistake?
Your Honor, the case law specifically mentions acts of parties and attorneys under the mistake consideration. And it narrows it down very much to mostly just acts of attorneys and acts of parties. Some court errors clerical errors like the one we had in this case with the court sending notice to an attorney who had withdrawn 18 months earlier, I would argue fall in that rubric as well. But for, again, we're considering them separately, but for counsel's mistake, Mr. Montoya would have retained counsel, been made aware of the hearing, and would have appeared. As soon as he got the belated notice, he immediately started seeking counsel. And I know the other side has faulted Mr. Montoya for not calling the court once he found out and reaching out to the court. And I don't think that's the standard that applies. When a withdrawing attorney's, when an attorney withdraws and the other party sends a notice to appear or appoint counsel, they are given under the rules 21 days to find new counsel. So the rules contemplate the idea that if somebody was represented, they don't have to immediately jump into court the next day and represent themselves while they're looking for counsel. They're given that grace period. And I think that that idea kind of defeats this concept that, oh, they should have contacted the court immediately. They had no intention of representing themselves. They had never.
No, but it was in the court file, the incorrect street address. And I think that the point is that even if it's going to take you 21 days to line up new counsel, you need in the meanwhile to be in touch with the court. Because I liked your characterization, metastasize. We have a way of repeating and repeating and repeating mistakes in things like address once they're in the record. Mr. Rojas, for his part, is using the addresses that the withdrawing attorney had used in his notice of withdrawal. I mean, what should be more reliable as an indicator of the current addresses of one's clients than the very attorney himself? But he dropped a digit, totally aside from the question of whether or not mail ever gets to street addresses as opposed to P.O. boxes in Beaver, Utah. The address was just plain wrong. So I think the implication is, yeah, it's going to maybe take you a while to engage new counsel, but you really need to get after this business of correcting the record with the court, or there's going to be more mischief caused by this incorrect address floating around.
Well, Your Honor, I have two responses to that. First, Rule 76 in its plain text requires attorneys and unrepresented parties to update their addresses with the court. Only attorneys and unrepresented parties. It does not require represented parties to do that. That's why we have the 21-day grace period, so you can decide if you are going to be represented or if you're going to go forward on your own.
But the moment when the former attorney has withdrawn and before you line up the new attorney, aren't you at that moment unrepresented?
I would argue I would argue technically you are, but again, that's the purpose of this grace period, to give you a chance. If you immediately were acting pro se at that point, there wouldn't need to be a grace period, and you could be called into court the next day before you had new counsel lined up. And secondly, I would say, Mr. Rojas, he knew that those addresses were incorrect. The address on file with the court belonged to the widow of a friend of Mr. Montoya. It was where he was initially served. And they were on notice that that was a bad address and it would not reach Mr. Montoya. And they also knew that the address on the notice of withdrawal wouldn't arrive because of the P.O. box issue. And they got all of their mailings to Beaver returned to them. And I think it's hard to argue that repeatedly using bad addresses that you know are not going to work when you do have a reasonable alternative is not reasonably calculated to give notice as required by due process.
Is there something in the record that indicates that Mr. Rojas knew that both of these addresses would not actually reach the defendants? That the street address in Beaver and then the other address where they were apparently served originally, is there evidence in the record that Mr. Rojas did not know that those were good addresses?
Well, in terms of the address on file with the court, there were briefings involving that initial service, and there was a motion to quash that his counsel addressed. So he was on record, on notice, that that was not a correct and good address. And in terms of the second address, Mr. Rojas has lived in Beaver for some time, and he undoubtedly is well aware that P.O. boxes are required.
But there's nothing in the record to that effect? We're making an assumption?
There are copies, I think it's a reasonable assumption, but there are also copies of their returned mail that they received from the Beaver addresses. And some of those were returned before they sent out subsequent mailings, again, to those same addresses. And while, technically under Rule 5, once you mail it to the last known address, you're golden. But when you know it's a bad address and you know it's not going to reach there, it's hard to say how that is reasonably calculated to give them notice.
But the standard for due process, following rules of mailing, is not the same standard for due process for service under Rule 4, is it? I mean, you need due process under Rule 4 to initiate your lawsuit, and that's where this language comes, reasonably apprised, reasonably certain to apprise somebody of a lawsuit. They have to be served, but once they're served, then doesn't the law presume that they know that there's this lawsuit pending?
Your Honor, I
mean,
would say
the rule says you need to send it to the last known address.
yes.
That kind of is loaded language in and of itself, that's where the line's gonna be. If you have no other address to send this to, even if we know it's not gonna get ultimately to who it needs to get to, where else are we supposed to send this?
I think right there is the point we're making, Your Honor, is they did have another address. They had the business. They knew where the business was. Mr. Rojas worked there for many years. They had been given permission to initially serve at the business. And in Davis v. Goldworthy, which is a Utah Court of Appeals case from 2008, in that case, defendant's counsel withdrew because the defendant kind of disappeared from the face of the earth, moved, stopped returning calls, and so the plaintiffs, they sent notice to his last known address and to his business address. And the court found in that case that that was sufficient. They knew that the last known address was bad because his counsel said it was, but they included the business address, and they found that that was sufficient. My time's almost up. I just want to draw your attention to one other case. It'd be Sewell versus Express Lube. And I think that mirrors what happened here very closely. It was a Utah Supreme Court case. And my time is up.
Do you have the citation to that case?
Yes, it's 2013 Utah 61.
It's in your brief.
Yeah, it's in the brief.
Thank you. You'll have your 3 minutes for rebuttal.
Thank you, Your Honor.
We'll hear from the other side.
Good morning, Your Honors. Christian Jones here and accompanied by Justin W. Wayman of Wayman and Jones Law. We are appearing on behalf of the appellee Alfredo Rojas. May it please the court. I wasn't 100% sure how you would want me to best proceed in this, so if you guys want to ask questions, great. If you just want to start that way, or I can just start going through this, and when you have questions, let me know. So whichever you prefer.
The latter would probably be the typical way to go,
All right.
unless anybody has a burning question right off the bat, and that sometimes happens.
Okay, I listened to a few of these before, and so I just saw that you liked to ask questions, so I thought I'd ask. Okay, this case has been full of delay. There's been one delay after another. And the problem is the appellants have never provided good, valid mailing addresses for both of them. So you've got a problem where an attorney withdraws and they do not provide an address for one, but they provide it for the other. Or they don't provide them for either. And so it's kind of hard to hit a moving target. It's hard to serve people when they don't follow the rules. Now,
Well, and it surely didn't help matters that the defendant's appellants were represented over the course of this by 6 or 7 different attorneys.
that's correct. Mr. Stone and Mr. Milner are the 5th and 6th attorneys that they've had, and we've received different attorneys or different addresses from each of them. And as far as the addresses go, if I could just address that. The first address, which was wrong, they were served at that address, they moved to quash it. It may very well have been a friend's house. However, they were served there, and we knew that they may get it there. And if we don't have another address, where are we supposed to send it? On top of that, the business address, we don't have the business address, and we never have had the business address. When Mr. Rojas was operating the taco shop, he had all of his personal mail and business mail delivered to him. And any deliveries were delivered directly to the shop. So he never had the P.O. box that the appellants had.
And the street address would have suffered from the same problem as the other Beaver addresses?
That is correct. And the problem that you have with that as well is I can contact the post office and request the address, but they will not give me a P.O. box. So I have no way of getting his P.O. box without him giving it to me. And Rule 76 specifically says that an attorney or unrepresented party is to promptly, and as Judge Orme pointed out earlier, as soon as that attorney withdraws, you are unrepresented.
Do you think it's a fair reading of basically the last 50 years of case law that says when it comes to this issue where when somebody gets a default, that the law doesn't like a default? In fact, I think there's even a case back in the jurisprudence that says that it abhors a default because at the end of the day, a default does not address the merits of a case, and it is the preference of the courts in a general statement that things be decided on their merits. And so here we have a case where, sure enough, they didn't show up to a pretrial conference, and for that reason, they were defaulted. And within 15 days, they have 90 days to file it, but within 15 days, they file a motion to set that aside and say, it's on us, it's bad on us. You know, in my experience, many courts would have maybe done something like, well, you missed it, so yes, I'll set aside the default, but I'm gonna make you pay some attorney's fees to compensate the other side for having to show up to something that didn't happen. But once that's paid, they really can't show any real prejudice. It's been a 15-day delay. How does that fit in with this case law that we have? And it's literally legion that says that we should have a preference to decide cases on their merits and not on a default basis.
Well, there's a lot of ways to go on this. So first, they filed the motion to set aside on June 15th, and the default judgment was entered May 23rd, so it was a little longer than 15 days. But at the same time, this was the second pretrial conference that they had failed to show up to. The first pretrial conference they didn't show up to. Judge Lyman passed it to second call. I tried to contact Mr. Marshall, could not get a hold of Mr. Marshall.
But that's their lawyer not
Yes.
showing up, not them.
Well, they
right?
didn't show up either. Nobody was there.
Was there a specific order in the first pretrial conference the parties had to be present?
There was a notice of pretrial conference that was sent out. I don't recall if it required the parties to be there, but either way, myself and my client were there, and nobody showed up from their side. Mr. Marshall did not answer the phone, and I just so happened to call our office, and my office, one of the paralegals said, well, we got a letter this morning that said that they want to go to mediation. So I went back and I told the court that, and we went to mediation. But that was the first pretrial conference that they missed. So yes, they do not like to determine it by a default, but where a party has had so many delays and not shown up for things and not participated in good faith, and on top of that, where there is not a meritorious defense, the court has no alternative but to deny setting it aside. Because if you don't have a meritorious defense, there's nothing to have a trial on. And both judges, if you look at it, both Judge Lyman and Judge Barnes said you did not at any point present a meritorious defense or anything close to it. And Mr. Lay's response was he chose to focus on due process. And then in their request for a rehearing, the defendant's meritorious defense is simple. Plaintiffs are lying about the terms of his agreement. Well, claiming an opposing party is lying is not a meritorious defense, especially without more. On top of that, Judge Barnes also found that Mr. Rojas provided proof of his payments to the appellants. So Mr. Rojas provided proof of everything that he claimed, and through that proof was able to show that they had not proffered a meritorious defense.
I have a question about this meritorious defense aspect. When we say meritorious defense, are we actually looking at the merits of the claim, or is the district court supposed to look at the merits, or is it just that assuming that if their defense were to prevail, they would be relieved of liability?
Well, it has to have merit. So what they look at is, can that be proven? And the district court is in a unique position to judge the credibility of someone's proffer. If that proffer is not credible, it reduces the merit. And the district court is able to provide weight to different, different elements and say, well, I don't believe this is meritorious because you cannot prove this. If you cannot prove it, there is no meritorious defense. And the purpose of a meritorious defense is to prevent having a trial on something that is frivolous on its face.
But isn't that putting the cart before the horse a little? Does a defendant who's seeking to set aside a default judgment actually have to come forward with evidence to essentially prove that their defense is going to carry the day in order to be entitled to relief from the default judgment?
Well, this situation's a little bit unique in a few respects. The first is they did a request for a rehearing, and in that request for a rehearing, they say, well, for purposes of setting this aside, we have now provided a meritorious defense. So they took 2 bites at the apple. The court indulged them, and they got another bite at the apple, which isn't provided for in the rules. So they took another bite, and they missed. The court said, look, essentially, Judge Barnes said, we have specific proof that you cannot prove what you're saying. We have specific proof that you had bank accounts that you had Mr. Rojas deposit money into for the monthly rent payments, not this other bank account that you said belonged to Ms. Swanson's husband, Mr. Swanson, so you could not provide those records. If you look at all of the delays and missed deadlines up to the before the order, or before Mr. Stone entered his notice of appearance, there had been 218 days where they had missed deadlines by X amount of days or not responded. There was a period of time of 108 days after Mr. Spendlove, their second attorney, withdrew, where they had no communication with the court. We sent stuff to addresses, which they did receive, but they had no communication. We had no idea what was going on. And then, after Mr. Marshall withdraws, there's 42 days where there's nothing. So their response was, well, the court should have sent it to these addresses, received them back, and found out there was a problem and done something about it. Well, what they want the district court to do. It's not our job or the district court's job to track them down. I specifically stated in the Robbins case, once a party has appeared before the court, it is that defendant's responsibility. It doesn't say the court, it doesn't say the plaintiff, it doesn't say the defendant's attorney. It says the defendant's responsibility to maintain contact with the court. And so their failure to do that is ultimately the history of this case, their failure to participate in good faith. They don't have any documentation or any evidence that would support any of their claims, and because discovery is over, they cannot support anything that they've said. So there is no meritorious defense.
Did the district court rely on the prior delays in this case in denying the motion for relief from the default judgment?
I don't know if it expressly did, but that may have been a factor. I think it should be a factor where a party doesn't participate in good faith and doesn't keep themselves apprised until they get a default, and that gets their attention. The default is entered on the 23rd, and sure enough, they have an attorney that enters a notice of appearance that same day.
Was the notice of default judgment sent to the same addresses that the prior documents were that they say they didn't receive?
It was. And so,
And somehow that came to their attention.
well, and that's the thing. They say, well, we don't have to provide our address. Well, the rules are the way they are so that this does not happen. That we don't have delays, that we don't have one party trying to pin somebody down and figure out where they're at and what's going on. This type of behavior is the antithesis of judicial economy. And so this is something that the rules are very redundant in saying, hey, you need to provide your address. Rule 10, you have to provide your address. Rule 74, you have to provide your address. And they say, well, we don't have to appear or appoint within that 21 days. No, it says you have a responsibility. That is your duty to respond. So if you have received it, you need to appear or appoint. And if you choose not to, then what are the other parties supposed to do? Just wait on you? A Rule 60B motion is based on equitable principles. Equity is fair. What is fair? And unclean hands is something that comes into play. It's similar to this situation. You cannot go into a court and ask for equitable relief if you do not have clean hands. And where there's delays, there's a failure to follow the rules, that's unclean hands. I can't ask you to do equity when I have not. And that is a very well settled point of law in Utah. And I think that point helps to alleviate this type of thing happening in the future. I hope I've answered your question on meritorious defense. Is there?
No, I don't have a follow-up. Thank you.
Okay. So now I've got to figure out where I'm at. I've got 1 minute left. Well, basically because there is, no, that's wrong. So as far as due process goes, only reasonably calculated to inform the parties. We talked a little bit about how they were tag team partners. We did not get any mail back from California. They're brother and sister. They're communicating. He's taking the lead, which i.e. means she's not participating. As a matter of fact, there is zero excuse or mistake or anything else on Ms. Swanson's part. There is nothing in the record that would indicate that she should be excused from anything or that any part of this appeal should be granted.
And I
in
think
her favor.
that might go to the point Judge Mortensen was asking about earlier. Should these two defendants be treated differently in terms of relief from the default judgment?
That depends on how you want to view it. If you want to view them separately, then Ms. Swanson still has no excuse. My time is almost up.
It seems to me that we would be to otherwise treat them as anything but separate would be basically concluding that Mr. Montoya was an attorney in fact for his sister. In other words, we're going to impute some sort of agency relationship there and use one to hang the other, which I don't know that we have any case law establishing that that's correct.
Well, I'm out of time.
You can go ahead and
Okay.
answer.
It appears that their position is that, yes, he was acting as her agent, and so she should be able to bootstrap off the mistake, and she should be able to have a do-over
Not to
again.
put too fine a point on it, but we don't allow that. We don't allow pro se people to represent each other
Yeah.
as a matter of law, right?
Yeah.
And
That's
so he can't act in court, in documents, as her agent in court, because that's basically being a lawyer, right?
Yes.
Okay.
So, but I guess on the flip side, where he doesn't provide a good valid address, which, by the way, we still do not have a valid mailing address for him. They've never provided one. So where he fails to provide one, but we know that they're working together, we know that they're brother and sister, and that they're communicating, it is reasonably calculated to inform Mr. Montoya if that mail goes to his sister, Ms. Swanson. So we sent it to all the addresses that we had, satisfying the requirements under Rule 5. And on top of that, because of their relationship, because of everything that's gone on, and because of their failure to follow the rule and provide a valid mailing address, I think that he received sufficient notice as well based on failure to follow the rules. He lost that due process argument, but also Ms. Montoya or Ms. Swanson was served, and that would go to him too. And sorry, do you have any other questions?
Apparently not. Thank you.
Thank you.
3 minutes for rebuttal.
Thank you, Your Honors. Jacob Stone again for the appellant's defendants. Jumping right into a meritorious defense. The Seventh Circuit specifically said in Biegnack v. Taylor, which is in our brief, the actual likelihood of prevailing on his defenses is not the measure of whether he has a meritorious defense. Other case law says you just need to state your defense in short and simple terms.
Well, what was in the initial motion to set aside the default, what meritorious defense was stated? Not the rehearing, but the original document filed with the court.
If I remember correctly, that one authored by a prior attorney focused solely on Rule 60b-4, and under 60b-4 there is no meritorious defense requirement. In our request for a rehearing, we included Rule 60b-1, and we included a meritorious defense. And
how many days after the entry of default was the motion for rehearing filed?
Let's see, the decision on the initial hearing was in...
Let me ask a better question. Was it more than 90 days after the default was entered?
Yes, I believe it was.
Do our rules or our case law allow you to do that? Can you make a motion to set aside the default under one provision of the rule, and when the court rules against you, can you make a motion for rehearing on a different basis and avoid the 90-day bar?
Your Honor, I would say that it is up to the judge's discretion, and the district court judge allowed the request for rehearing, the request for reconsideration, I forget how we phrased it, to go forward.
So he didn't have to, but since he did and did engage in it, then we should review it.
And the meritorious defense isn't simply just a claim that he's lying. It was more detailed than that. It was supported by the declarations of both Mr. Montoya and Ms. Swanson that were submitted with that. Their recollection of the oral agreement with Mr. Rojas was very different, and they were basically laying out their testimony of what their recollection was. Testimony is evidence. Declarations are evidence. So it was inappropriate for the court to find that plaintiff provided proof of his payments to the defendants. That's besides the point. The court missed that when its real responsibility was just to look at what the defendants were proffering and see if that, if proven, would eliminate or provide some relief and recovery. A few other quick points, Your Honor. The district court's decision makes no mention of this supposed history of delays and failures to cooperate. We dispute this 218-day number, but that's besides the point. The scope of this appeal and this decision is whether or not the district court in its decision was correct or not. And I would finally say that the parties are ready for trial. They've certified they're ready for trial, so it would not be a hardship to allow this to go forward and to be resolved on the merits. Thank you.
Thank you. We appreciate the arguments from both sides. We will, as is our custom, take the matter under advisement, think about it, discuss it among ourselves, and then let you have a written decision as soon as we're able to get that taken care of. It could be days, it could be weeks. It's typically months, but hopefully not many months. With that, court will be in recess. We'll come around to the front, take off our robes, and do Q&A, which is purely optional. I would let the audience know, those who might be thinking about questions, the one thing we won't talk about is the case we just heard. A question, which attorney did you like best? How are you going to decide this case? We won't entertain. And so while the attorneys and parties are surely welcome to stick around if that's of interest to you, you're surely entitled to hear the Q&A. Don't feel obligated. We will not be discussing your case further. So if there's other things you need to be doing with your time, feel free to excuse yourselves, and it won't be held against you. With that, we'll be in recess and look forward to being joined up here by Mr. Jones.
All rise.
On behalf of the students, the faculty, and staff of Southern Utah University, let us thank you for coming down here for the 10th year in a row. And President Wyatt is traveling internationally, so he asked me if I wouldn't moderate. I'm going to start the judges off with a question or two, but I would invite you to come forward, stand behind this mic, and we'll take the next, what do we have, Jennifer, 15 minutes or so, and 15 or 20 minutes, and have you ask questions to the judges. Many of our students are at an age in their life where they're trying to figure out what they want to do with their career. And I think they would be interested in hearing from all three of you as to how you decided to become a lawyer and a judge, if you'd like to speak to that. Who would like to go first?
I can certainly go first. I never considered being a lawyer. I didn't know any lawyers growing up. I literally met my first lawyer when I went to law school. I'm a first-generation college grad, and when I was at college, I was actually studying acting. I wanted to be a film actress. And along the line, I started taking some courses in public speaking as well, and in conjunction with that, I was able to take a class called Freedom of Expression, which I didn't know what it was, but it was basically a survey of all of the U.S. Supreme Court's First Amendment cases over the years. And I said, oh, this is law? This is fantastic. I love this. So I decided sort of on a whim to take the LSAT, like the SAT, but for law school. Ended up applying to the University of Utah, and once I got there, I still didn't know if it was going to be for me. It really clicked, and so I was very glad that I found this path and that I was open to it as well, and willing to change when I found something that really interested me.
I decided when I was in 4th grade that I wanted to be a lawyer, and that was because I wanted to go into politics. And it came to my attention that lots of politicians started out as lawyers. I lost my interest in going into politics probably partway through college, but at that point was so laser focused on becoming a lawyer that I never revisited the reason for why I thought I'd want to be a lawyer. I graduated from the University of Utah, then went to George Washington University Law School in Washington, D.C. The first year I was out of law school, I clerked for a judge. That is to say, I was the executive assistant of a Court of Appeals judge. And at the end of that year, I thought, being a lawyer is all well and fine, but what I really want to do is be a Court of Appeals judge. So when the Court of Appeals was created a few years later, I applied and had the good fortune of being appointed. We have, sitting right over here with Trooper Barrett and Lisa, our clerk of court, my law clerk, Shad. He has spent the last year or so being my law clerk. That's what I did for a Court of Appeals judge. He is a proud alum of this fine institution, as a matter of fact. So a good way to break into the legal profession is spending a year working for a judge. That's when I became convinced that I wanted to be a Court of Appeals judge.
My story is a lot more convoluted. And to begin with, I want to endorse a short book for you all to read. It'll make your life better. It's by Clayton Christensen, who I think is the dean of the Harvard Business School, or at least teaches there. and it's called How Do You Want to Measure Your Life? And it's his retrospective looking at all these Harvard guys that he went to school with. They all got really good jobs, making all sorts of money coming out of school. And then he went back 20 years to reunion, and they were all miserable. So they were rich and miserable. And they're all divorced and estranged from their children. And he took a step back and said, why is that? And it's because there was a disassociation between their values personally with people and what they wanted to really have, which turned out to be a good family life, and they didn't realize that their career path and what they really wanted in life were two different things. But an important point of that book is he says you should have a plan going forward, and I fully endorse having a plan. And then he says, and you should be ready immediately to change the plan when something comes up that you didn't anticipate. And that's my story of law school, being a trial lawyer, becoming a district court judge for 10 years, and then ending up on the Court of Appeals. Now, this is my dream job. And in fact, as a law clerk in a law firm, I once had a discussion with a partner about what was the best legal job in the state of Utah, and we decided then and there that it was to be a judge on the Utah Court of Appeals. And then 20 years later, I got the job, so that was awesome. But this is how it happened. I picked my undergraduate school, unlike most of you probably thought, where am I going to get a good education? I didn't care about that. I wanted something centrally located for rock climbing. And I wanted to climb in City of the Rocks, Idaho, in Colorado, Utah, and in Vegas during the winter. And I looked on a map, and the most central school for rock climbing and with close rocks in Rock Canyon was BYU. So I decided to go to BYU, not because I'm a Cougar fan, but because the rock climbing is so awesome. And so once there, I took courses that I actually liked, and that's why I was an English major, because I can write. I hate science, and I'm terrible at it. As it turned out, I'm actually not as terrible as I thought. It's just that I didn't care what X was. But later in my career, I did tons of physics for accident reconstruction, and then I cared what X was. And lo and behold, I can do conservation of momentum, all that good stuff in physics once I cared. So I have this English degree, and I don't know if any of you are majoring in English, but then you have this decision. Are you going to be an English professor, unemployed, or go to a graduate program? And at that point, I decided, I'm okay at writing. I think I'll go to law school. And I said to myself, and what do I think I'm going to do? I'm going to be a transactional lawyer. Because at the time, there was a show called LA Law, and that looked glamorous. And so I thought I'd be a transactional lawyer. Now that I know what transactional lawyers do, number one, I would have hated it and probably quit the practice of law, because it's a miserable way to spend your days just with writing up contracts for other people. But I clerked at a firm during law school, and these guys were trial lawyers. And so I was going to court almost every day, watching what they do. And I thought, well, this is fantastic. I want to do that. So I begged, and they hired me, and I became a trial attorney. I tried many, many cases, and really enjoyed that work. But one day, I was looking at this judge on the bench, and I thought, I could do that. And so I applied to be a judge, and then I became a district court judge, and lo and behold, that kind of was a good setup for me to get this dream job that I thought about on the Court of Appeals. But my point is that is exactly what Clayton Christensen was describing in his book. I did not have a plan to get from point A to point F, which is being a Court of Appeals judge, but as the opportunities came about and I found new things that interested me, I just went with it. So I had a plan. My plan basically was to go to college, but after that, I just kind of took life where it took me, and I couldn't be happier.
That's two of us that went to law school because of LA Law. So, do we have some students, faculty, staff that are ready to ask a question? If not, I'll ask a follow-up.
And I'll offer an incentive. We have souvenirs in a little box right down here. Cool pencils that are made to look like gavels, pocket constitutions, and little buttons that say, I heart Utah courts, law nerd, and other such things. Anyone who asks a question may then reach into our goodie box and take as many items as would be polite. Think of yourself like trick-or-treating. Take a pencil, a constitution, a button, and that's your reward for being bold enough to come and ask a question.
It worked. We got a taker.
I'm just here for the pencils. But I'm very grateful that you made the trip down to Cedar City today to hear a case. As I was thinking about this today, I wanted to know, what, as judges, do you wish the average person knew about the court?
Well, that's a really good question. And I guess the main thing I would like people to know about courts is they really are kind of a last resort. We've had a couple cases where, you know, the first thing we say in our conference is, oh my gosh, can you imagine living next door to that person? You end up in court to work out this dispute. Courts are expensive and in some ways inefficient. And a lot of times people, both sides leave unhappy. Even the winner is sometimes unhappy with the result because they feel like, well, I should have, you know, I got what I wanted, but I should have had it 3 years ago and without having to pay $40,000 to lawyers. So if there's a way that you can resolve your disputes without coming to court, that's really the best idea. Courts really are the last resort when it comes to dispute resolution. Try and work things out with your neighbors. Try and work things out with your spouse. We joked in the session yesterday with some students, if you're going to speed at no more than about 7 miles over the speed limit on the freeway, because no, 5, don't go more 5. You can go a little over the speed limit, but don't go a lot or you're going to be pulled over. So that's one thing I would like people to know about courts. And well, I will see you in court. Be very reluctant to go right to that. If you can work out your problems without having to hire lawyers, without having to go to court, you'll be happier in the long run. And that's probably not the answer you were looking for, and I may have colleagues who beg to differ.
Well, I had a thought. What I would like the public to know is that when we make a decision, it's not necessarily because we think that that is the right result or that it's good public policy. Most of the time, in fact, almost all of the time, we are applying the law as it exists and as the legislature has enacted the statutes. Sometimes it turns out that there are situations in which the legislature didn't realize what kind of result would happen when the law as they wrote it was applied to this set of facts, or maybe there's just some really good public policy arguments for why the law should change, but that's not at all in our purview. We can't change the law, we just have to apply it as it exists. And if the law is bad and the public at large does not like the result, the remedy is generally to lobby the legislature to change the law or appeal it or amend the Constitution. But sometimes I think it's not clear that there is a distinction between what we would do if we could do anything as individuals or what we thought was just fair. We are not roving doers of justice. We can't make something fair if the law doesn't require that result. And so that's the distinction I'd like the public to understand.
I'm going to endorse one thing that Judge Orme said, and that's that if you can resolve your dispute, you should do it, not give it to us. And I used to try to explain to people that if you know your individual lives much better than we do, and so you can make nuanced decisions about how you want to move forward with disputes. On the other hand, we do surgery, but we use sledgehammers, not scalpels. And so if you think of that image as surgery with sledgehammers is what the court does, we will answer your question, but we typically do it in a way that's not as nuanced as private settlements are. The one thing I want to say about the courts is we are the most transparent branch of government, period. Our courts are open. You can go right now here in town to the 5th District Court in Cedar City and walk into court and watch what we do. Nothing happens behind closed doors. If a judge talks to a party outside of the courtroom without the other side there, that is sanctionable. If you did that enough and were caught, they would remove you from the bench. We don't do that. Our function here as an appellate court is even more transparent because the decisions that we reach, we write in written form and we publish them. They're on a website. So you could go literally right now, go to the Utah Court's website. If you wanted to read every case we've decided this year, they're right there for you to read. And so we don't have any backdoor stuff because that's what happens in the legislature. Sometimes they work things out by compromise behind closed doors. We don't do that. We talk things through to be sure, and sometimes we argue about what the exact language should be, but at some point we have to vote, and we put it in writing, and it's all out there for you to read. And so my thing to the public is the courts aren't as big of a mystery as you think they are. They're only a mystery because you don't go to court to watch, and you don't read what we write. We spend hours and hours and hours writing these things, and sometimes nobody ever reads them. And that's okay. I mean, the lawyers read them, and then the parties read them. But my point is, if you really wanted to know, we're not a mystery. You can go read exactly what we've written.
Would you speak to how you became a judge? It's very different than, say, our neighboring state of Nevada, where they run like politicians. And then tell us what the typical life in the day of a judge is like.
I can talk about how you become a judge. It's a fantastic process in Utah. We have a really high caliber bench because of all the vetting that takes place. Anyone can apply to be a judge. Well, not anyone. You have to be an attorney and over a certain age. But you can submit an application process. It's very transparent. There is a nominating commission that is appointed by the governor, and it has to be bipartisan. There have to be an equal number of Democrats, Republicans, and some independents. And what they do is they look at all the resumes, all the applications that they receive, and they choose a number of people to interview.
And I think it's important, just to let me
Yes,
interrupt,
please.
that it's also a ratio of lawyers to non-lawyers.
That's true.
The commission's half members of the public. Like, we don't want those lawyers because they think weird. So we want normal people to decide who should be our judges, in part.
That's right. We have public members, there's public members and attorney members. And so they decide who to interview. They bring those people in for an interview. And then they vote on who they're going to nominate or send up to the governor. So what they do is they send up 5 names for a trial court position, or for an appellate court position like ours, they send up 7 names. And the governor has a certain amount of time that he has to choose one of those 5 or one of those 7 people. And there's a whole nother series of interviews and background checks and that sort of thing. And public comment, too. It's published for public comment. Once the governor selects someone, that name goes to the Utah Senate. And the Utah Senate has their own public comment period. They have a committee hearing where they can ask us questions and delve into our backgrounds. And then after they recommend us out of committee to the full Senate, the entire Utah Senate has to vote on our position. And then we're confirmed and can be sworn in as a judge. So it's a really lengthy process. And then I think this is a good idea. A lot of states have elected judges. What we have here is sort of a safety valve almost, I like to think of it. A judge doesn't have to get impeached to be removed, not like in the federal system. Instead, we stand for a retention election. So about every 6 years, the first time's about 3 years after you're on the bench. When you look at your ballot next year, you'll see that it says should Diana Hagen be retained as a judge of the Court of Appeals? And it's uncontested, so there's no one else running against you, and you just vote yes or no. And that's another check. If you really have a judge that somehow gets through this gauntlet of screening or just takes the bench and is really derelict in his or her duties or something of that nature, there's a way for the public to vote that person out, and then the process would start again.
Dave, I think you should talk about the typical day of a judge, because only you, among the three of us, were both a district court judge, that is to say a trial judge, and a court of appeals judge. And my guess is how those two judges spend a typical day is dramatically different, and maybe you could enlighten the group about that.
Sure. As a district court judge, I took the bench most days at 8:30 in the morning, worked straight through, maybe with a recess until noon. Usually took about an hour for lunch, but not every day, 'cause sometimes there wasn't time. Be back on the bench at 1 and work till 5. On a typical criminal calendar, where you have people who are somewhere in the process, they've been recently charged, or they're there to make a plea or whatever, it's not uncommon in a single day to hear 100 cases. Yeah, it'd be packed like this, and we just call them up one at a time, and some of them it'll only take 30 seconds because they say, hey, we're still trying to get information from the prosecutor. Good, we'll see you again in 2 weeks. If somebody's going to take a plea, we take the time to make sure that they knowingly and voluntarily are doing what they need to do. Other days, I would hear motions from the parties. We might set a matter for trial, or I might be actually in trial. And so I was in court every day. On the Court of Appeals, at most, I will be in court 3 days a month. So way different. And a really long day at the Court of Appeals on the bench would be 3 hours. I did 10-hour days on the bench during trials in the district court. But then where the real work comes, and actually I will tell you that being a Court of Appeals judge work-wise, I think is actually harder than the district court, because a lot of the stuff you're doing in the district court is very repetitive and doesn't take a lot of thinking. Certain things do, but not everything. Here in the Court of Appeals, everything takes thinking. People don't appeal cases because it's expensive if it's a stupid question. They come with good questions, and so the actual underlying work's harder. But then we, again, have to write up everything that we do. And so the easiest way for me to explain it to you, and don't have this be a turnoff. I know this, every time I say it, students look at me like, ugh. It's basically we write 4 term papers a month. Because our decisions, the lawyers' briefs, by the way, that maybe you saw us tussling around up here with, their page limit's 50 pages. And so the briefs, I don't know why they use that word because they're not brief. The briefs typically are, 150 pages of reading plus the appendices. So there's tons of reading, and then we have to put it in written form. We have law clerks who help us, and if we didn't have them, we would drown under the load. But it's just a whole bunch of writing. But good writing is an awesome thing. You know that, right? So a good book is a great thing, and legal writing can be interesting, and it's kind of like taking a puzzle apart and putting it back together in a way that you can communicate to other people why you're reaching the conclusion that you're reaching. But most of what we do is not in court. We just spent 30 to 40 minutes with these lawyers. Well, we spent way more than that reading their briefs, and we will spend significantly more time now crafting a decision to explain ourselves.
We earlier this morning, very few people attended our 10 o'clock argument, but we heard argument in another case this morning at 10. Same exercise. We read the briefs, we got ready, we heard the arguments of the attorneys. We'll talk about the case, we'll figure out who's going to write the opinion. And in addition to the 10 o'clock argument and the 11:30 argument, this same panel of 3 judges also considered 2 other appeals that had been fully briefed, just like these, but they were cases, our time being as precious as it is, cases where we thought, you know what? We've got this. We've read the briefs. We understand what's going on. We don't need to trouble the attorneys to come down and argue. We've got all the information we need just from the briefs here. So Two of our 4 cases today got the sort of the Cadillac treatment, as we sometimes call it, argument and all the rest. 2 other cases, the Volkswagen treatment. We've read the briefs, we'll conference, we'll think about it, they'll still get a written decision. But our workload was about 50% more than would have been obvious today. But pursuant to Judge Mortensen's comments about us being transparent, we do a lot of work that won't necessarily be obvious if you come into our courtroom.
Thank you. We have time for a final question, please.
Hi, thank you so much for being here, first of all. Earlier, Judge Hagen, you mentioned that the law isn't always fair, and so I was just wondering how you mitigate that as a judge between what you believe is right and your own personal opinions and then the law. How do you kind of balance those two? Thank you.
Generally, one of the things...
Don't forget your souvenir.
One of the things that we have to do as judges and that we promise to do is set aside our personal views or any opinions we have about the way the case should be resolved. So we really do try to set that aside and be cognizant of it. We all have our, I guess the term, implicit biases, and that we have to be aware of and make sure that they're not creeping into the decision. But one of the things that law training does, and that good judges do, is they really separate the application of the law to the facts from what you would do if you were in the situation, or if you could just resolve it in terms of general equity and fairness. And so we always have to look to the law. And in fact, I can give you an example. There was a Supreme Court opinion issued about a month ago, and you would notice in the footnote that the author said, it is not our prerogative to decide whether this law that was passed by the legislature is good or bad, or if it's good public policy or bad public policy. Our only job is to apply it. And if the people of the state and their elected representatives believe that it's bad public policy, then they can change it through the legislative branch, but not through the judicial branch. And we just have to set that aside.
I want to mention, it has nothing to do with the last question, but we should make the point that we are not the whole entire Court of Appeals. If any of you were here last year, you saw me and Judge Appleby and Judge Harris. We are a court of 7. And we sit in what we call panels of 3, but the court itself actually has 7 judges on it. Of interest, at present, we have 4 women and 3 men. So the panel that you see here is not representative of our court. We are a female majority court at this point, which sort of got us a headline mention in the National Association of Courts of Appeal, because that happens.
The Tribune.
And the Tribune.
Front page of the Tribune.
Oh, that's right. So that was kind of a big deal. When I first came to the Court of Appeals, there were two women. 2 of the 7 judges were women, and then our world has changed in the last 32 years, or however I've been on the court. Many more women entering the legal profession, many more women getting to a point in their careers where they can be seriously considered for a judgeship. And so happily, I say, as the father of daughters, happily these few decades later, we have a court that is more female than male. And we are quite proud of that, the males as well as the females.
Well, again, on behalf of the university, we thank the 3 of you for being here and your staffs as well. I think I saw you at the Shakespeare Festival this summer from a distance. Were you not here?
I was indeed. In fact, now that you mention that, we like to come in October in part because we can catch the tail end of the Shakespeare Festival. So I was down earlier, you're right. I came with my daughter in July, and while I'm here, I'm going to extend my stay a little bit and see 4 plays, 2 for a second time, and Hamlet and the Price for the first time. But those of you who haven't found your way to the Shakespeare Festival, you really need to go. Students get in for next to nothing, right? Standby basis or something, and you owe it to yourselves while you're here to take full advantage of that wonderful opportunity that the university affords.
Let's give them a big round of applause.